Michael Morton was convicted in 1987 of the murder of his wife. After 25 years in prison, with the help of the Innocence Project, DNA tests supported his claim of innocence. Subsequently, Morton was released from a Texas prison in 2011. But the story doesn't end there. Now there are charges of prosecutorial misconduct in the handling of evidence in the original Michael Morton case. Tonight, a closer look at our criminal justice system, the overturning of convictions, and the work of innocence projects across the country. I'm Ernie Manous, and this is Houston 8. Joining us tonight are Nicole Casares, attorney and professor, University of St. Thomas; Anthony Houghton, Thurgood Marshall School of Law Innocence Project, Texas Southern University; and John Raley, attorney for Michael Morton. In the interest of full disclosure, Mr. Raley also serves on the Association for Community Broadcasting Board, which is a fundraising board for Houston PBS. Before we start, remember you can share your thoughts throughout the show on Twitter using hashtag Houston8. And welcome to all of you. My first question goes to Nicole. I slaughtered your name, didn't I, at the top there?
Well, it's a hard name to say. Okay.
And it is?
Casares.
Casares. Mm-hmm. Welcome. Thank you for joining us. Now, we started talking about Michael Morton, but you were heavily involved in the Anthony Graves case.
Yes, that's right.
Which, once again, was another overturning of a conviction.
Yes, that's right.
Tell me a little bit about how you got involved in that case.
Actually, I got involved through the Texas Innocence Network, which is here at the University of Houston Law Center, and Professor David Dow had received an inquiry from a journalist, actually a freelancer, who had done a piece for NPR, and she was just concerned after she learned more about Anthony's case. She said, really, somebody ought to be looking into this. So Professor Dow offered me and my students the opportunity to investigate his case, and we took it.
And Anthony, you get cases in a very similar way.
That's right. We get letters from people who are locked up routinely. We get about 60 requests for help a month.
How can you handle all that? How do you decide which of those 60 are worth following?
We have a screening process which involves a questionnaire, but we're looking for two kind of discrete things. We're looking for cases where either there was no offense, or if there was an offense, that they simply got the wrong person, they convicted the wrong person. And so screening for that can become relatively easy with trained students, and we use law students to do the screening process for us.
And John, your case came from another Innocence Project, the New York Innocence Project.
Yes, sir.
And how did that come to you?
I got a call in 2004, and they asked if I would volunteer to represent Michael Morton and try to get DNA testing on a bandana that was found near the crime scene that had blood on it. And I agreed to take the case pro bono.
Why did you agree to take the case?
Well, I'd heard about the Innocence Project, and I'd heard about the quality of their work. I read the file and was initially convinced that there wasn't evidence to convict Michael Morton. And then when I met with him, I became fully convinced that he was innocent. And so we dedicated ourselves to try to exonerate him, and we did.
Okay, here's a broad question. Any of you can jump at this one when I throw it out. Why do we even have an Innocence Project? Why should there be a need for it? Shouldn't the work that you're doing within these projects automatically be being looked at and dealt with through the criminal justice system as part of regular procedure?
We have a need for innocence projects because the criminal justice system is run by human beings, and human beings make mistakes in whatever they do. So mistakes are bound to happen. We can have the best criminal justice system in the world, but occasionally there'll still be a mistake.
But I don't question that part of it, but what I'm wondering is they have to bring in independent, you all work pro bono when you work on these cases, and you come in to help do this work. Something is bringing to attention, folks, that there was an unfair verdict. I'm trying to think of the right word, so I know when you get to the legal terminology. But if they need to then find somebody who will handle it pro bono, that they need to look outside of the regular system, shouldn't this be something that we have seen enough of these cases to realize this happens and it should be built into the criminal justice system?
I think there's increasing awareness of these issues. One of the things that was very difficult for us to grasp was the resistance to DNA testing in the Michael Morton case.
I guess that's what I'm talking about.
I mean, the bandana was clearly something that would have been tested if the murder happened today.
Explain the bandana, because people aren't following the story as closely as us.
It was a bandana containing blood that was found behind the house where Christine Morton was murdered. DNA testing was not available in 1987. We always thought, when we filed the original motion in 2005, that it may contain Christine's blood and the DNA of a person, not Michael Morton, but a person who may have murdered Christine. And it may lead to a hit on the databanks with millions of available choices to a known offender, which is exactly what happened. So we never really fully understood, and still don't to this day, how law enforcement and the district attorney could fight a test that could only reveal the truth.
Tony, is it money? Is that what we're talking about here? Is
I
it
don't
so
think it's
costly?
just money. I think what happens, and I'm probably the last person to argue the state's point of view, but there's an interest for the victims of these crimes in having finality, and there's an interest for the state in having justice carried out. And so when you have those two things coincide, the courts look at the process and say, we want to make all of the important issues happen at the trial. So the courts have worked in the post-conviction process, which is a process that we do after the person's already been convicted, to try to shut down all of those avenues of post-conviction with the idea of making sure that the trial is the actual time or the event that decides whether the person is guilty or innocent.
Well, I think in Michael's case there's more, because he is a crime victim. His wife was murdered when he was at work. And I think there was a sense in the community that they didn't want people to be afraid, that we have a quiet little town. Don't worry, as the sheriff said in the newspaper about a week later, there's not a serial murderer out there. So there was that sense of let's just check the box and say we've solved it.
Nicole, what do you find your students' reaction to all of this?
They're shocked to see that things can go so wrong sometimes. And yes, we may all agree that the system's human, it makes mistakes, but the state doesn't always want to face up to those mistakes and make them right.
Why is it so resistant? I mean, I understand what both of you are saying about that, but we have seen time and time again, especially in a case where DNA wasn't available at the time of the conviction, and now DNA is available.
Yes.
Why then do they fight it so much if isn't their main purpose wanting to get justice and a correct answer in these situations?
Well, it is for some district attorneys.
Why wouldn't it be for all?
I don't know.
Well,
I
understand.
think that's just a very human question. Some people have difficulty admitting that mistakes have been made in prosecution of someone. Others are a little higher and a little more removed from it and willing to say, let's just make sure we have the right man or woman. Let's make sure that, let's be smart on crime. Mm-hmm. and seek the truth. Some are more willing to do that than others.
And it may be also part of the process that we have is an adversarial process. And so some prosecutors are going to buy into the idea that the person that they are convicting is guilty. And I think for many of them, even those that tend to be progressive, they dislike the idea of convicting anyone that might be innocent, so much so that it almost becomes like cognitive dissonance. Well, because I've gotten you convicted, you must be guilty. And so once that's happened, it becomes very difficult for them to want to undo it. Mm-hmm. On top of that, we have all of our judges and all of our prosecutors in Texas are elected. And so there is also this public perception that they want to be seen to be doing the right thing. They don't want to be seen to have been making mistakes.
Yeah, Nicole?
Well, I think there are some bad apples out there. I think there are some prosecutors who want to get convictions, and it's a notch on their gun, and they want to. Yes, they have to be reelected, and they want to be tough on crime, and they want to get the bad guy, and sometimes that creates blinders, it creates tunnel vision, and they don't look as carefully as they should.
Mm-hmm. I will say that I am guilty, and have been guilty, I'll say. Let me preface it with believing, all right, maybe they didn't do the crimes they're convicted of, but it got to the point where they were picked up and brought in all the. They're probably guilty of something. And I say I used to do that because after reading all that I've read and going through all of these cases, you see the sheer number of mistakes that are made where someone wasn't. But is that school of thought still out there? Are you battling that perception that, well, maybe they didn't do this crime, but they probably did a crime?
I didn't have that in the Morton case because he was never accused of any crime in his life. He was a college graduate. He was the manager of the Safeway. There was never any accusation that he was in any way violent, anything other than a loving husband and father. He went to work in the morning, kissed his wife goodbye, and it was a normal day for him at work until he came home and there was yellow tape all the way around his house.
Yeah.
But the others have had to encounter that, and of course that's wrong.
Right.
You have to analyze this matter before you.
I think in the Anthony Graves case, I think there was some of what you described. Anthony was a young African-American man, and I think there was some racism in a rural Texas county. And, he had to have done something. I think there was some of that. He had never been accused of a violent crime. He had a minor drug possession charge. That was all that he ever had. And that attitude, we just can't have that, especially in a capital case, in a death penalty case. We can't put someone to death for a crime they didn't commit just because, maybe they did something else.
Can't imagine anything more horrible.
And in the Gary Graham case, I think that was one of the main arguments that was fronted to his claim of innocence.
Give me a little background on that.
And Gary Graham's case is a case from the early 1990s where he was supposed to have killed a person called Bobby Lambert. And there was only one eyewitness against him at the time of trial. The way the case was tried, there was implication that he had the murder weapon, but the actual ballistic testing had shown that he wasn't, so there was some fudging of the ballistic evidence that was presented to the jury. There was as many as 12 other witnesses found in post-conviction, many years after this case, who all said that Gary Graham was not the killer. But he never got a proper hearing on the case, and he has since been executed. But one of the arguments that was proffered all the time to say that he deserved the death penalty was that he had been involved in a number of other cases. And it was those cases that led to him being arrested, and then this case being put on him as well.
Is part of all of your work then to combat that ignorance first and
Yes.
then get to the case itself? How do you proceed?
Well, I remember when we were ready to file the motion and we did all the research, I called the district attorney based on the advice of my father, who was a retired prosecutor, just to see if he would agree to the test. And because it can only reveal the truth, And he said it would muddy the waters. And I said, truth clarifies. I've never understood why he would oppose something that can only reveal the truth, that would be free to the state, because
Nicole
the Innocence
is shaking
Project,
her head. What?
the Innocence Project would pay for it. We've all had to encounter this sort of thing, but I want to say that there are many men and women that are prosecutors out there that are doing it ethically and honorably and really trying to make the world safe. We've encountered some that are concerning us, but
Right. And your case gets even thicker because there is now concerns of prosecutorial misconduct.
we have uncovered evidence that the prosecutor at the time had available to him strong evidence of Michael Morton's innocence, which was not shared with the defense, like the Supreme Court requires under Brady versus Maryland, and was not in compliance with the court order.
And that's going forward. That's a separate case. and
That's
being
going
looked
forward,
at.
and I just want to say that prosecutor has a right to a fair trial on that point.
Right.
We believe in the rule of law, and so he'll have a chance to make his case on that.
One thing that goes along with that is that that's an extremely unusual case. In all of the cases where you see prosecutorial misconduct, where you see prosecutors hiding evidence, where you see police officers bringing informants that they know or should have known were lying at the trial, where you see them misleading folks in the eyewitness identification procedures or coercing confessions out of folks. There are very, very few cases where prosecutors or police officers or even the informants, when they find to be lying, are ever prosecuted, ever feel any kind of sanction for any kind of wrongdoing. So the Michael Morton case is a unique case in the sense that the prosecutors may end up having to look at and addressing what they did wrong in that case.
It may be part of the national movement, the national consciousness going forward, the good work of these and countless other people trying to make people aware that these sorts of things can happen. But I do believe that the Michael Morton case is perhaps a watershed that will help bring our law forward a little bit as we try to do a better job seeking justice.
So, Nicole, what can happen? What can happen moving forward?
Well, in the Michael Morton case, I believe that the former prosecutor could be charged criminally.
And I'm not just talking about that case. I'm
Okay.
talking about in general in our criminal justice system. What can change because of what we're seeing at this level?
Well, in my opinion, one change that would be beneficial would be if prosecutors weren't given absolute immunity for knowing and intentional misconduct. Because now that's what they have. So take that off the table. Give them qualified immunity. They have immunity for good faith mistakes, but if they intentionally and knowingly hide evidence, manipulate, fabricate evidence, they should be held accountable.
Are there not days when all three of you think it's just a lost system, or do you still have as such strong faith in our criminal justice system?
I'm hopeful. I believe that we move forward. If you look at just the things that have happened in my lifetime in civil rights, I don't want to hear about the good old days. I want to talk about how we've moved forward toward more liberty and more freedom. And I really think that we're going to move forward in how we do justice as well.
And I think that's absolutely correct. When you look around the criminal justice system, and Harris County particularly, I think is a good example. For many, many years, we were one of the largest cities in the country that didn't have a public defender service, that was paying really pennies on the dollar compared to other people for our indigent defense, and we were getting what we were paying for. And now we have a public defender's office in Harris County that is doing stellar work. There's a movement for a public defender's office in Fort Bend County, and those kind of offices have been proven to increase the quality of representation, which leads to reduced levels of wrongful conviction. The causes of wrongful conviction are really well known now because of the DNA cases, the 289 cases where people have been found to be innocent. We see that the main problems are eyewitness misidentification. We see the second largest problem is false confessions. Almost a third of the people who are convicted of DNA cases, where the DNA comes back and shows them they're innocent, give confessions. And these are the most serious cases. These are murder cases and these are rape cases. And they're DNA cases because that's where the police bother to collect the evidence. And so you have this whole swath of other cases where there's no DNA, where there's very little work being done, but the same kind of policing, the same kind of prosecuting, the same kind of defense attorney work is being done in those cases. And so it really raises a question of how many people out there may actually be innocent and that we may never be able to help.
What we see in those confession cases, my law partner, Bobby Bowick of Raley and Bowick, was with the Air Force, was an officer, and he trained cadets in what to do if you're shot down and captured, how to stand interrogation. And he says, just give me 20 hours in a room and I can have anybody confess whatever I want them to. Those cadets knew that he couldn't hurt them, that it was all fake, and yet he had them signing statements that they were criminals and that America was an evil country.
That's something that I see coming up time and time again when I'm looking at these kind of cases is as the evidence mounts that it might have been a wrongful verdict, that there are these documents put in front of these inmates that say, sign this confession, confess. What is that all about? What is going on there that they're being asked to confess to it or to go for a lesser crime?
It's an easy way out for them. When we were on the cusp of getting a DNA result on Michael Morton, they offered him a parole first time. If he would
he was life, no chance of parole.
Yes, he'd already been in for 23 years. And they said, you can have a parole if you only show remorse for your crime. And he said, all I have left is my actual innocence. If I have to be in prison the rest of my life, I'm not giving that up.
So then what is motivating them? And I know I'm asking you to play mind reader and to guess what's going on here, but from where I sit, it looks like they know that there might be an overturn of the conviction. Why wouldn't they want to know the truth? Why would they rather get you to sign this document to confess you did it and then we'll sweep you away? Why isn't there outrage within those offices saying, no, let's find out the truth?
I think increasingly there is. That's the point I'm trying to make. More and more and more.
Okay.
You see things now like the district attorney's files are open. They can't hide things anymore in their files if the district attorney of that particular county chooses to have an open file policy, like in Harris County, like in Austin, like in Dallas, like in other places. Then the defense attorney can come and see whatever evidence there is. And that's really a more recent innovation. Not true in '87 in the Michael Morton case. We found all those concealed things.
And again, I want to say, we are talking about very unique cases. We are not talking about across the board. We're not talking about all prosecutors. We're not
Right.
Right. That there are a lot of very hardworking, good people out there trying to live to the law and find truth and justice.
And increasingly there is a movement toward not resisting DNA testing because you see these kind of results where these people are exonerated, and at some point more and more prosecutors are going, okay, worst case scenario is we find out that this man or woman is where they're supposed to be. So what? Let's at least find out the truth, because if they're not where they're supposed to be, then they should be out.
And that may well be the most shocking thing to the students that I have, because students try objectively to look at these cases because the standard for proven actual innocence is very, very high. So you can be convicted on a lot less evidence. You can get rid of all of that evidence that convicted you and still not be able to prove your actual innocence, just because of the way that it works in the law. But the students that I have, when we get the cases, and it's only very few of the cases that we get that ever rise to that level, but when they get cases where it is almost certain that the person is innocent, and then we present them to prosecutors, and the prosecutors just wave off this idea that this person may be objectively innocent. It comes as quite a shock to them. I mean, it's really eye-opening to them that objectively, if they can prove that they're innocent, that the state might not be interested in undoing the case. There are things that we can do, and there are things that the legislature is doing. Recently, last year, I believe, they passed the law for eyewitness identification, for changes in that. But we need more. We need changes, for example, with confessions. And there's no reason, given the technology that we have, that people cannot be videotaped from the time that they come in the door of the police station till the time that they leave throughout the investigation process. In the eyewitness identification process, it's very simple to have another officer, one who doesn't know who the supposed suspect is, give the photo array or do the lineup. That way there can't be any sense that the officer who knows who it is, who knows what it does, is influencing what is being done. Where we have, for example, police officers and prosecutors not turning over the evidence, we need prosecutors like the one in Dallas, who is making sure that that's starting to happen.
Yes.
And like the prosecutor that we have right here is starting to make sure that that information is turned over. Unfortunately, we still have a few that are not, but it's starting to become now, I believe, the trend. And so I agree that it's now become the trend where prosecutors are not stomaching the old way of doing things.
Nicole, let me ask you this, just for clarification too, for our audience. A jury's verdict becomes law, becomes the final say. Mm-hmm. When evidence comes up that questions that, the jury verdict still stands, correct? How does that work legally?
Okay. Well, there's the appellate process. When someone's been convicted, they get the right of a direct appeal, which is an appeal where the appeals court only looks at questions of law. Was the trial conducted fairly and pursuant to proper procedures?
So you can't introduce new evidence.
Can't introduce any new evidence, but then through the ability of filing a writ of habeas corpus, that's where someone who's convicted can try to introduce new evidence that wasn't considered by the jury. And if that's successful, then, well, perhaps the judge will grant an evidentiary hearing, and perhaps the conviction ultimately will be overturned, and then the state has the option to retry the defendant, have a new trial. Okay. Or perhaps even release the defendant if the evidence is that strong.
So they are legally guilty until some judge at some point overturns the verdict.
Correct.
No matter what evidence comes out, no matter what DNA testing comes back.
And it's a very high standard. I mean, in order to get your conviction overturned on a habeas appeal, it's very difficult. There are many, many hurdles. And another change that I think would be beneficial would be to make it not so hard. Mm-hmm. I mean, if we really care, the problem is, and especially with respect to death penalty cases, at some point we have to cut off the ability to appeal. Otherwise, we can never enforce the ultimate punishment. Mm-hmm. But what if the day after that cutoff date, the new witness comes forward? I mean, I think we're all familiar with the Clarence Brandley case, which happened some years ago, but the evidence of Mr. Brandley's innocence came at a very late stage, and the laws have changed now. And if that had come forward today, Mr. Brandley would already be dead. He wouldn't have the ability to ever get that new evidence.
That was actually right. Michael Morton's first line in his very first press interview the day that he was released.
Right.
He said, "Thank God this is not a capital case, or I would not be here today."
Right.
And there was a hush over the room, and nobody really knew what to say, but everybody kind of absorbed that for a while. But I wanted to say that as part of the progression that we're seeing, Senator Rodney Ellis has done more, in my opinion, than any legislator in Texas in moving us forward, and has shown tremendous leadership in that regard. I would have
to say, and credit to him and all that we're talking about. But to take us back a step, I can't imagine there is anyone on death row, a couple, that aren't saying I'm innocent. The people that are given life in prison, that most of them are going to claim they're innocent.
My client actually would disagree with you on that.
Really?
Anthony,
So would Michael.
Yeah, Anthony says that on death row, there are many inmates who will admit that they are guilty. They may have legal claims. They may say that they had ineffective assistance of counsel. They may say that they participated, but they weren't the triggerman. They might have mitigation claims, mental retardation, childhood abuse. Those are legal claims, not factual innocence claims. Now, I don't know how we can document that, but
Right.
someone who was on death row says that that's the case.
And I've done death penalty work for more than 20 years, and in that time I've had 2 clients who said that they were innocent, and Gary Graham being one. And the death penalty cases are unique in Texas because the prosecutors usually don't bring them unless they have a really high sense that the person was actually involved in the case. And so the case becomes more about the punishment than whether the person actually committed the crime.
And you are all being punished right now because we're out of time. So we have to stop. But fascinating work, and thank you guys all for the work that you're doing and all the help that you're doing.
So it was a pleasure to talk to you.
Thank you.
Delighted.
Now, each week we invite you to visit our home online at houstonpbs.org/Houston8. There you can read about the guests, learn more about the topic, and even watch past episodes. Now, next week on Houston 8, a look at the Urban Land Institute Gerald D. Hines Urban Design Competition and what those ideas will mean for the future of Houston. That's next Friday night at 8 p.m. right here on Channel 8. And that does it for us tonight. Until next time, I'm Ernie Manous. Thank you for joining us, and have a great week.